Good evening, everyone. I'm Daniella Levine, Cava, County Commissioner, District 8, and I want to welcome you to our first ever Land Use and Zoning Workshop. We are so grateful that you're joining us and very, very excited to have our lead attorney from the County Attorney's Office, Dennis Kerbel, with us to lead us through understanding the maze of land use and zoning. And how, as members of the public, you can participate. And I have to tell you, I've wanted to put this workshop together for a long time, right, Dennis?
That's correct.
That is correct. I've been asking for a while because I've been sitting in on these hearings now for 6 years as a county commissioner, and I see that members of the public are often at a loss as to how to have their voices heard. And I want to be sure that you have all the tools you possibly can so you can be effective in your role as speaking up on behalf of the community for your interests and concerns. Here we are. Necessity, the mother of invention. We're doing it virtually because originally we were going to do it in person, but here we are in Zoom land. And we have some wonderful people behind the scenes making this all work, including posting it on Facebook, and it will be available later for people to view. Maybe those who missed it, you can share, or if you want to go over it as a refresher. So I think you, those of you who know me know I'm very dedicated to civic participation and citizen involvement in government. So zoning and land use is obviously a big part of that because it affects quality of life issues where you live and where you work. And so it's something that's very, very personal. The state land use and zoning process can be very confusing. I certainly am continuing to learn, and I'm sure I'm going to learn things today from our session. But I'm hoping that today we'll be able to untangle it a bit for everyone. This is really designed for people that don't have a lot of knowledge. So if you're an expert, it'll be a refresher. But for those of you who really don't practice in this area, you're going to get a lot of information to help you become more active and effective as a community advocate. So before I was elected to County Commission, I knew very little about land use issues. But now that I've served, I see that it is a great, great opportunity for public engagement. As I said, Dennis Kerbel is our lead attorney. So he knows as much as anybody about this process. It's going to be conducted today as a workshop between me and Dennis because technically he provides legal advice to me as a county attorney to county commissioner. He doesn't provide legal advice to the public. So the advice will come through me, but after our exchange that is going to be outlined for you on the screen, there'll be an opportunity for you to weigh in with your questions as well. So now to let you know a little bit more about Dennis. Dennis is a great guy. And he's been with the County Attorney's Office since 2002. He is the chief of the Zoning, Land Use, and Environment section. We talk to him all the time. And today we had a huge meeting on some amendments to the Community Development Master Plan. They've been worked on for at least 2 years. It was quite an important meeting, and he guided us through, just to let you know. He's also a litigator who's practiced at the federal and state court levels, trial and appellate. He handles zoning appeals, enforcement actions, federal civil rights claims, and has prosecuted numerous civil cases seeking custody of animals found in distress, another issue of great importance to me and I'm sure to all of you as well. He is also an adjunct professor in his spare time at FIE College of Law and St. Thomas University College of Law. So let's get started. We're going to set some ground rules for you. They will govern both the elected council members and commissioners, and by extension, the applicants and the public. So let's start with the ground rules. So Dennis, can you please explain the main laws that govern public meetings and specifically some of the land use laws that we have to take into account? And we're going to split the screen at some point and you'll be following along with the outline. Thank you, Dennis.
Thank you, Commissioner, and thank you for the kind words. So let me start with the most basic rule that applies to all public bodies in the state of Florida, which is the Sunshine Law. The Sunshine Law means that the members of the board cannot speak to each other about items that will come before the board outside of an official meeting. So that constrains the ability of one commissioner to meet with another commissioner unless they call a special meeting, referred to as a sunshine meeting, for that purpose. And it applies to matters that are reasonably foreseeable to come for a vote, not just things that are actually on an agenda. And so for sunshine meetings, there has to be notice to the public, the meeting has to be open to the public, and minutes are taken. So that's the most basic of the provisions that governs boards. There's also, in the state of Florida and also locally in the county, there are ethics rules that govern what are referred to as conflicts of interest, that are technical legal conflicts, such as a board member not being able to have a financial interest in the outcome of something that that board member is voting on. It prohibits the personal or private benefit of members of the board from a board's decision. It requires financial reporting. It requires disclosure of any gifts that are received, and it also imposes limitations on board members doing business with the county. All of those matters are things that are enforced by the Commission on Ethics. And so anybody that has questions about conflicts of interest, whether they're a board member or whether they're a constituent, you would see the Commission on Ethics for those sorts of issues.
Excuse me 1 second, Dennis. Let me just give an announcement for the benefit of our listeners. If you have a question, unfortunately, we don't have the chat or question answer function in this Zoom. So you can do two things. You can send an email to district8, the number 8, at miamidade.gov, or you can text Andrea Picardo at this number, and I'll repeat it twice, 305-721-8929. So again, email to district8 at miamidade.gov or text 305-721-8929, and we'll be gathering the questions to review them later. Thank you. Sorry to interrupt you, Dennis.
Please, by all means. So the sunshine law and the ethics rules are the things that govern everything that every board does, regardless of whether it's a land use proceeding or an advisory board on any number of topics that the county has. I wanted to just take a moment to address the role of the county attorney's office. Our attorneys are the attorneys for the board and the administration. Our responsibility specifically in this process is to protect the board's decision-making discretion by ensuring that due process is observed and appropriate procedures are followed. We strive not to take any position on the issues, not to take any policy positions that is for the elected officials or the other policymakers on the board. Our only position is to ensure that whatever decision the board ultimately makes is legally defensible.
Okay, great.
And then just a little bit of background on laws that specifically govern land use proceedings and decisions, things that we as attorneys have to keep in mind when advising on these matters. There is, of course, the Fifth Amendment of the United States Constitution, the Takings Clause, which prohibits the taking of private property for public use without just compensation. There's the Equal Protection Clause. We have to make sure that decisions are not based on race, ethnicity, religion, national origin, or other protected class, or that the decisions don't impair fundamental rights, such as freedom of speech or other important First Amendment rights like religion, freedom of establishment, or sorry, free exercise, or the Establishment Clause. And we have to strive to ensure that due process is afforded at all levels. The thing that is important to know about due process is what is required depends on the type of proceeding. So planning, and we'll talk about this in a little bit, the process that's required for planning is different than the process that's required for zoning. And then there are some specific federal and state statutes that are in the background that also implement the issues that are addressed by the constitutional provisions. One is the Religious Land Use and Institutionalized Persons Act of 2000, which is RLUIPA, which relates to regulation of religious land uses, as the title mentions. There's also the Byrd-Harris Private Property Rights Protection Act, which is Chapter 7 of the Chapter 7D of the Florida statutes, which is a step. It doesn't require a full taking as would be required for a Fifth Amendment challenge. It provides additional property rights matters that you have to be cognizant of. And then finally, there's also the relief from burdens on real property rights for governmental exactions, which we'll talk a little bit about later, also in Chapter 7 of the Chapter 7D of the Florida statutes. And so in all of these types of proceedings, these things are in the background. And I think that was mainly what I wanted to cover about background laws, unless someone has a specific question later, or you do, Commissioner.
Well, let me just ask, are we going to cover appellate processes later?
Yeah, we could do that when we talk about zoning.
Okay,
and
very good.
about planning, yeah.
Very good. Okay, so do I say, let's start with the big picture. I'm trying to think what I've said versus what you've said. Okay, so land use decisions are split into two distinct but connected processes. One of the most confusing but important things is to grasp the difference between land use planning and zoning. So let's start with the big picture of land use planning. What is the CDMP, as it's called, and what does it do?
So the CDMP, that's short for Comprehensive Development Master Plan. That is a document that's required by the Florida statutes, what's referred to as the Growth Management Act. It was revised in 2011, so now it's also referred to as the Community Planning Act. And it requires every local government, and the county has a particularly robust plan, it requires every local government to examine its population needs, its infrastructure needs, with specific reference to avoiding urban sprawl and other major issues, environmental protection, protection of agriculture, and to set out policies that will then guide subsequent regulations, what are referred to as land development regulations, like zoning. So the idea was to establish what the case law has called a constitution for land use that then governs subsequent decisions. The important thing historically to understand, and I think some of the questions we've gotten in advance suggest that there is some confusion about this, is historically zoning ordinances were adopted first, dates back to the turn of the 20th century, and those zoning ordinances were in place in many communities, including in Miami-Dade County, before the requirement at the state level to adopt this comprehensive plan. So, so you have to go through both stages if you want to make a change to your property, or you may have to go through both stages. But changing the comprehensive plan is not enough to implement a particular land use. So the idea being this is policy level and bigger picture things, although there is also a land use plan map. You see applications to change what the land use is. And if you'd like, we can go through that step now. Okay,
but just there were 2 points on that last slide. If we could go back for a second.
Sure.
If you could just explain the levels.
Sure. Okay, so procedurally, an application to amend the CDMP, such as the ones that we saw this morning, if they are related to specific properties, they go to the community councils for recommendation. Then, and those are specific to the council that covers where the property is. Then all the amendments in that cycle or in that package go to the Planning Advisory Board for recommendation. So the Planning Advisory Board sees all of the proposed amendments, regardless of whether they went to community council or not. And then finally, they go to the Board of County Commissioners. If it is if it's an application that covers 10 acres or less, then it can be considered what's called a small scale amendment, in which case it has one hearing before the Board of County Commissioners, and the County Commission can take final action at that hearing. So a small scale would have gone to community council, planning advisory board, and then to the county commission for a final decision. There's another type of amendment if it's larger than 10 acres or if it's a policy change that once the county commission hears it the first time, it makes a decision about whether to transmit it for state review. And then various state agencies, including the Department of Economic Opportunity, the Department of Environmental Protection, the Water Management, the South Florida Water Management District, FDOT, and several other agencies, the Regional Planning Council. All of those will give comments to the county if they deem it appropriate to give comments, if there's a state resource that's implicated. And then when those comments come back, the county commission will then take final action to on the application. So they're small scale and they're standard, and they have two different tracks. And then, once the county commission makes a final decision, then there are additional steps that that can happen.
Okay, great. Okay, so please continue.
Sure. So once the county commission makes a final decision on an application, then it is subject to challenge under a procedure that's set forth in Chapter 163 of the Florida statutes. The specific reference is 163.3184. And the in that process, you would go to basically a trial. It is a trial before an administrative law judge who makes recommendations and findings of fact. And then after that, it goes for final agency action at the state level. And after that, it is subject to appeal to the District Court of Appeal, which is the appellate court, the highest appellate court before you get to the Florida Supreme Court. So that's the process. And it's worth pointing out that the standard of review is what's referred to as the fairly debatable standard. And I want to take a moment just to explain, if I can, what that means. What it means is that the state agencies in this process are supposed to give deference to the local government, to the local elected officials on the matters that they are establishing policy on. And so the question is not, is this the best policy that the local government could have chosen? The question is there some basis to support the policy that was chosen? Could reasonable minds disagree about it? That's, in a nutshell, the fairly debatable standard. It's not supposed to be a do-over as to the underlying policy debate. The question is, specifically under the Florida statutes, one of the main ones is it internally consistent with your existing CDMP? And is there data and analysis to support the action that you chose? And the staff reports are quite robust, and the staff reports usually, they're certainly designed to meet that standard.
Okay, very good. So we can advance to the next slide. Okay. All right. Why should we?
Actually, maybe we should go back one. There were a couple things that we
didn't cover. Okay, very good. So, so what about the Growth Management Act? Did we talk about that?
Yes, that's the statute that governs the requirements.
Okay, very good. Okay. Okay, so talk to us about the opportunity for public input. Sure.
So most applications, well, I shouldn't say most. If you're a small scale amendment, so it relates to a specific piece of property, there will likely be an opportunity before the community council, subject to quorum and some of those issues, but an opportunity to have your say to the community council, to ask the community council what they're going to recommend. There's another public hearing opportunity before the Planning Advisory Board. And then there's a public hearing before the Board of County Commissioners before they take action. And if it's a standard amendment, you have those avenues if it relates to a specific piece of property, and then you will have another opportunity, as we had this morning, for the public to be heard when the item comes back from the state review after transmittal. So there's 2 hearings before the county commission for a standard amendment.
And I know you and I, Dennis, spoke a little bit about this. How could a member of the public be most effective in making a presentation? And, because if there's an attorney, that generally each side is given an opportunity to present. But if you're a member of the public and you're not given sort of equal time, you're given a certain amount of time. And like happened today, the time was reduced from 2 minutes to 1 minute. And so you have to be prepared to be really quick about getting your points across. If the chair, this is all at the chair's discretion, if the chair decides to cut back on the time from the usual 2 minutes to 1 minute. So one of the things that I've seen is that when people come as a group and they organize their testimony to, be sequential, so that they're not all repeating the same points, but they're building on each other, that can be very effective in having their point of view heard. Can you make any other kind of style type suggestions about things that could be helpful to members of the public?
I can't really give style tips, but I think the example that you just gave is a good one, and I've seen it done effectively where members of the public have gotten together in advance and have sort of coordinated their points so that they're not all covering the same ground. I think the idea of the public hearing is obviously to provide not just your voice and your opinion about an application to the board, but also to provide information. So I think the board is always appreciative of specifics. It matters more for zoning, and I'll have more to say about that.
Okay.
But for the most part, in terms of how to present, it really is at the discretion of the chair and the board, because they have to manage the agenda and get through the items as well. So there are trade-offs. What I will say is that if you make a comment, then for future, if there's an appeal or if there's a hearing process, the Florida statutes defines what makes an affected person who's entitled to bring a further challenge. And one of the criteria is, did you give a comment to the local government at the transmittal hearing?
Oh, okay. So very important. So if you ever have the inclination and ability to take an appeal, you will have needed to have been on the record.
Yeah, the statutes require that.
Okay. So anything else about this, like the final say, the role of the commission decision, state review?
Just to note that planning is ultimately a legislative decision, notwithstanding all these other procedures that are required under the statute. But it's ultimately a legislative decision, like any other ordinance that the commission handles. And so, in the planning context, it is perfectly fine for constituents to reach out to their commissioners directly, or reach out to any other commissioner directly, and discuss their concerns about the application. It's just like any other policy, any other ordinance, where you're free to do that. Again, the Sunshine Law prevents the board members from talking to each other outside of the sunshine, and the ethics rules prevent board members from voting on things in which they are personally interested. There are technical criteria that the Commission on Ethics enforces, but it's policymaking, and the members of the public may reach out directly to their commissioners to express their concerns.
Okay, great. And thank you for underscoring that point, because obviously it's different when we get to zoning.
Right.
But on land use, you're free to reach out. That's why I've had many meetings with the public on these land use issues, but on zoning, I may not, and you're going to go over that in just a minute. So here we have a point about land use policies and how to make sure that the plan is consistent So could you say a little bit about that? What should the plan be consistent with? State?
Sure. So the statutes require the plan to be internally consistent. Now, internally consistent, it doesn't mean, and I think that the case law reflects this, it doesn't mean that every application has to further every goal and every element of the plan, because the plan itself is premised on competing goals. For example, preservation of agriculture is a goal, but so is preservation of environmentally sensitive land. But there are some places, I think probably in your district, where there's some overlap, or where they're right next to each other, and so a lot of the planning is in how do you trade off these competing goals. And internally consistent means that you look at what are the policies in the comp plan, and if you're furthering one set of goals, you would look at it one way, and if you are trying to further those goals but you're going in a different direction, then perhaps it's internally inconsistent. But that's one of the tests. The second would be that you have to be consistent with the requirements of the statute. So, for example, the plan amendment would have to be based on data and analysis. I think those are some of the significant guideposts. And one of the and for land use amendments in particular, the statutes have criteria. The statute has criteria that relates to the discouragement of urban sprawl. And so that's a statutory criteria that applies to plan amendments, and not just to the element as a whole.
Okay, great. All right, thank you, Dennis. And again, if anybody has a question, feel free to send it by email or text. And the email is to district8, the number 8, at miamidade.gov, and the text to Andrea at 305-721-8929. So before we go into zoning, which is certainly going to be more technical and lots to say, let's just talk a little bit about when properties do not have to go through either land use hearings or zoning hearings. So I get a lot of questions about new construction projects, and naturally people think that I must have voted to allow a certain development to happen. And sometimes I have voted either for or against a development, but most of the time I have not. So what is the process for a property owner who wants to build, for example, townhomes on a property that was zoned for townhomes in the past, let's say in the 1980s? Does that property owner need to have a public hearing to pull permits to build townhomes there? And if not, why not?
So the short answer is, if you're already zoned for townhomes, then you would not need to go for public hearing to approve a townhome project. You may have to plat, which is its own process, but that's much more of a technical review. And a
plat, just to stop for a second, would be, the exact boundaries and that sort of a thing. Is that?
That's correct. The plat would be where you look at the infrastructure and how it connects to the roads and how it connects to water and sewer and other sorts of configurations in relation to other properties, the surrounding properties. It is a very technical review.
Okay.
So while it's technically a public hearing, because the Florida Supreme Court has said it is, what can be commented on is quite narrow. Okay. But other than that, you would be able to pull a building permit and build your townhomes, and you would not have a public hearing on it. There is case law that talks about that government is not supposed to exercise direct control over the use of property. So that's why zoning is generally framed as lists of uses rather than one specific use. Because it's not supposed to be that level of direct control of the property. That runs into a Fifth Amendment issue.
Okay, very good. So thank you for that. And now let's turn to zoning. How is it different from land use, and why?
So whereas land use planning, CDMP, is the setting of policy, it's a legislative decision. Zoning is the application of law to a specific property. And so it falls into what the courts have termed are quasi-judicial decisions, which means that the board has to observe greater protections for the interested parties that are subject to the decision. Quasi-judicial actions include deciding whether to change zoning, whether to grant a variance, whether to grant certain special uses, sometimes they're called unusual uses or special exceptions. And they also relate to decisions on covenants that sometimes accompany zoning applications. Essentially, the board is acting like a court, hence the quasi-judicial part of it, because you're adjudicating, in a sense, the board is adjudicating how the law or the standards that are in the code apply to this particular applicant. So all the fundamental board rules continue to apply, but for quasi-judicial proceedings, and this is not just for zoning, this is for any quasi-judicial action. It could be certain permits that, certain environmental permits that go to the BCC, or other things that go to the Environmental Quality Control Board. There are a host of them. There have to be additional due process protections that apply, because at this point, the board is not acting strictly as a legislator that's free to consider whatever policy it wants. It is now having to apply these standards to the people that come before it. So the legal standard that courts look to is, was procedural due process afforded? That includes notice, an opportunity to be heard, an opportunity to cross-examine witnesses. The court would also look at whether the board observed the essential requirements of the law. Did the board apply the correct standards? And finally, is the decision based on substantial competent evidence? The core of due process here is notice, and it is strictly enforced. Then comes the opportunity for the applicants and other interested parties to present testimony and evidence to the board. In terms of a hearing, the rule of thumb is that the board has to give equal time per side. It's not per person. So the applicant and proponents get, let's say they take 30 minutes, then you would give the opponents an opportunity to have an equivalent time of presentation. They don't have to take up the whole time. They can say their piece. They can do it sooner. Obviously, the board is always appreciative when the hearings go faster, but there's a little more latitude. On the other hand, as we've had in the past, where you have the applicant give a 30-minute presentation, but then there are 100 speakers, each one of whom may want 2 minutes, or in some cases are given 1 minute. Now there has been more time given to the objectors. So it would not be in that case. I don't think it would be a due process issue to say we're going to limit the amount of time that people are going to speak. Ultimately, the board chairperson always has the discretion to control the meeting. That's the quasi part of the quasi-judicial. It is still a board meeting. They have to get through an agenda. And so in the interest of that, the board can control repetitive testimony. I'll pause here for a minute in case you wanted to follow up on anything.
Well, I do want to get a little bit more into the Jennings rule aspect of it, but I don't want to interfere with your line of description of how these hearings go.
Okay.
I do have to say I am an attorney as well as a social worker, and I really did find it perplexing that kind of not all the rules of evidence as I knew them applied to these settings. And so it's helpful to hear, that's what makes it quasi. But it can be extremely frustrating right? You know, and then they're asked, well, how much time do they need? And then we're going to hold you to it. And, you know, and then there's not endless back and forth. And of course, all the witnesses are sworn in, but, you know, not all witnesses are equal, I guess, in these situations. So any other thoughts about just kind of how rules of evidence are applied here?
Well, in that case, in terms of the rules of evidence, the swearing in makes it evidence that can be relied on. And that's the balance, as you mentioned, between having people be heard and managing the meeting and still bringing the item to a conclusion. Because just like a court can manage, the judge can manage how long a witness can go for. The judge can rule that what the witness is saying is irrelevant and prevent them from speaking altogether. So we don't police it to that level either.
Yeah.
Come up
Well,
and say,
yeah. We had a very specific question here that I thought was a really good one from Amanda Prieto. And she says, you know, notwithstanding the Jennings rule, because of the short amount of time that members of the public are given, it's really not possible to effectively communicate sometimes the concerns about the impact to the family or the community. So what can people do with this limited time frame to be able to communicate to the decision makers, the commissioners, more broadly?
Well,
anything?
Let me start with, that's why I started with it's equal time per side. So if you had a situation where you had an applicant who gave a lengthy presentation and then you only had one or two objectors, if the objectors want to say a little more than the time they've been given, we will usually advise that they be given some latitude because of the per side, the rule of thumb, to keep it per side. But when you have 30, 40, 50 people coming up, I think most things get expressed, kind of the wisdom of crowds sort of idea, through the go at length and give 5-10 minute presentations and you have 30 people, and then you have multiple
Impact on safety in the streets, and another about traffic, or so that you really divide it up, and that way you can get you know, the ability to communicate more broadly on the issue that you can't do if you just do it as one person. So that's a kind of a tactic, I think, that could be deployed. Okay, and back to you, Dennis. The screen is back up. Okay.
Okay. So I had mentioned the ability to present testimony and evidence. Participants are entitled to cross-examine witnesses, but the chairperson can control the timing of cross-examination to manage the meeting efficiently. So they can, you know, the chair can decide, we'll let you do it, but you have to wait until the end until we hear from everybody.
Okay. Can you mention about what is substantial competent evidence, the standard?
Yes, I was going to get to that
okay.
in a little bit.
Okay, very good. I'll let you go at you go next.
Okay, thanks. So other due process rights. We've covered notice, opportunity to be heard, opportunity to present evidence, opportunity to cross-examine. You have the right to an impartial decision maker. This goes beyond the technical conflicts of interest that apply to all boards. So it means that a reasonable person believes that a board member is not biased, prejudiced, or has otherwise made up the board member's mind before hearing all the evidence. And I will say so everything that I'm saying today is a variation on the presentation that I give at a Sunshine meeting to community council members, and members of my section as well, give to community council members as an orientation session. And so this is also what we advise those board members. is a reasonable person going to believe that you're not biased, prejudiced, or otherwise made up your mind? And one of the examples that we've given is, for example, if your spouse appears on one side or the other, will the whoever's on the other side think that you are being you're likely to be fair? It's a case-by-case basis, and the answer may very well be yes, I can be, but impartiality is important. The decision can only be based on the record presented during the hearing. So this is the key difference between being a policymaker and being a fact finder. For comp plan or for the board's legislative items, the things that the board normally addresses, you're policymakers. You can consider whatever it is that you think is relevant to your decision. But here, the board is acting as a fact finder. And so everyone that's interested in the outcome has to be apprised of what is before the board so that they can comment on it. And the issue is whether the facts in the record show that the standards in the code are met or not met. So that's where substantial competent evidence comes in, and I'll get to that shortly. But the idea here is that it's a closed record. Board members can't rely on their own personal knowledge. It has to be introduced into the record. If it's a fact that someone wants to rely on, it has to be introduced in the record by a competent witness, which is why we advise board members, if there's something that's important to you, ask the administration, ask the staff support to go and find that technical information that is important so that it gets into the record. County professional staff is a great resource for that. And you can always move to defer an application until such time as someone else can bring back the information and testify to it under oath. And now I'll mention Jennings before I do substantial competent evidence. So the Jennings rule is really an outgrowth of the two concepts I just talked about the impartial decision maker and the right to have your decision based on the closed record that's before the board through the hearing that everyone is apprised of. So an ex parte communication is any communication, whether written or oral, that occurs outside of a duly noticed hearing between a quasi-judicial board member and any person regarding the subject matter of an application that is or foreseeably will be heard by that board in a future quasi-judicial proceeding. It's the equivalent of the judge talking to the prosecutor or the defense attorney without the other one being present. And in the case of Jennings versus Dade County, where the Third District Court of Appeal issued this opinion, the Third District strongly disapproved of ex parte communications in the context of quasi-judicial hearings. It specifically said they are inherently improper and they are anathema to quasi-judicial proceedings, because when it happens, it means that someone else who's interested in it may not be aware of what the communication was and may not have an opportunity to address it in the hearing. So our consistent advice to board members is to avoid communications, in other words, lobbying, outside of the hearing with all potential participants. That includes applicants, that includes objectors, that includes anybody else who has an interest, to avoid potentially tainting the record. Because the penalty, if this goes to court, can be not only that the board's decision is reversed for hearing, but it could also, if it's severe enough, it could also require the board member who received the communication to recuse themselves because they could not, you can't unring the bell. So to avoid putting board members in the position of having their decision be reversed or being unable to participate in the decision-making, applicants and other members of the public really should refrain from communicating with board members outside of the hearing. So I'll reiterate that CD&P is not subject to this limitation because it's not quasi-judicial. And I'll also take a moment to note that we recognize that other local governments handle this issue differently. There's a statute that, that tries to address and in some ways allow ex parte communications, but we have consistently expressed serious due process concerns about the communications because if the third district has said it's anathema to quasi-judicial proceedings, it seems difficult to square that with a process that would essentially encourage it to happen more. So that's Jennings, and I'll pause there, Commissioner, in case you want to ask me anything about that.
Well, and I'd just like to underscore for constituents that it could be very frustrating, I know, and oftentimes you're not sure if something is land use and you could talk about it, or it's Jennings and you can't. And I don't want to put anybody at risk of a case being reversed because we've spoken about something that is not permitted under Jennings. So I tend to be very, very conservative in that until it's more or less, it's like, it's zoning until proven otherwise. So I have to be sure not to cross that line, because otherwise I'll have to disclose it on the record, and then, you know, I could be disqualified from hearing the matter and so on. So I just want to apologize in advance or in retrospect for anyone who was frustrated. And that also goes along with email communications and social media communications. I know some of these zoning matters become very public. There may even be articles written about them, and basically I just make sure not to read them, either the emails, the letters, the newspaper articles, or the Facebook posts and so on. So I just want to make that very clear, right? That's correct, right, Dennis?
That is correct. That is a good practice.
Thank you, thank you. Please continue.
Sure. So the next thing about the due process considerations is the decision has to be based on the correct standards. So the standards are those that are set forth in the zoning code, and they have a bit of flexibility because compatibility is inherently fact specific, and compatibility gives the board a number of options in what to consider. Prior decisions of the board, prior decisions specifically relating to that property, and certainly covenants that were adopted with the zoning on that property also form part of the standards. And the staff report sets out what are the standards that apply to any particular application.
Dennis, let me mention something here. One of the improvements that I brought to the process was to allow these materials to be available online. So it used to be that it was only paper-based, and that made it very difficult for members of the public to get access to the materials. So could you explain a little bit about that, how we have virtual access?
Sure. The zoning agendas were folded into the same agenda distribution process that applies for the board's other meetings. And so all of the zoning, what we call the kits, which is the staff recommendation reports, are all available online through the same agenda website that you find other county commission decisions. There is also, by the way, all of the zoning hearing records, certainly the modern ones, I'd say within the last 5 to 10 years, I think they are all online. And older than that, they were digitizing the historical ones as well. The zoning hearing records are available online, so you can see everything that's in the file itself through, if you go to the RER regional, Regulatory and Economic Resources Department website, Miami-Dade County, on the county website, and you go to zoning, you can track through where the zoning hearing files are. There's also a land management viewer. I think if you just Google Miami-Dade land management viewer, that'll take you to the GIS. There are these wonderful maps, and they have a search function, so you can type in an address, and you can ultimately find the zoning records that apply to that particular property.
Okay, great.
So all of that stuff is available online, at least as much as they've been able to make it.
Well, I think that's a really good segue to the discussion about virtual meetings now that we have them. And if you could, is this the right time? Are you done with the last part of the presentation?
I was going to answer about substantial competent evidence.
Yes, that's right. Go ahead.
So yes, one of the important criteria for a zoning decision is that it has to be based on substantial competent evidence, which the courts have defined as evidence that a reasonable mind would accept as adequate to support a conclusion, and that establishes a justifiable reason for support of or opposition to an application, issue, or matter. Now, keep in mind that the quasi part of this is ultimately the courts, much like the fairly debatable standard, are supposed to defer to the local legislature or the local body which has seen the evidence, and so the courts are not supposed to second guess how much weight to give evidence. The courts are just supposed to look at, is there evidence in the record? The weight is for the fact finder, for the board to decide. But in terms of materials, maps, site plans, elevation drawings, and similar materials have been found to be substantial competent evidence. If you can point to something on a map, if you can point to something on the site plan. The staff reports themselves, as long as they're not just a conclusory opinion, like we think this is good, the staff reports and the county's staff does a very good job of laying out the rationales in their materials. Those count as substantial competent evidence. Citizen testimony does count, and this is maybe something that might be helpful to the folks who are watching this one, this seminar. So area residents are competent to testify to the neighborhood compatibility of a project, and that testimony can include concerns about the project's aesthetic impact on their area. And there are several cases that have held that when area residents get up and testify about things like, that's going to be the tallest building in my view, and there's nothing else like it for miles. That sort of, it's got to be specific. That sort of fact-based testimony can be substantial competent evidence. But, and this is important, mere generalized statements of opposition are to be disregarded. That's what the courts have said about this. So it's not enough to say, I don't like it. It's not enough to say, we don't need this kind of thing around here. It needs to be more specific about the impact it's going to have on the area for it to be something that we can rely on to affirm a decision to deny an application, for example. And the courts have also been very clear that zoning is not a plebiscite. It's not appropriate for a board to decide based on how many people are in favor or against an application. You're not supposed to count heads. I will tell you that petitions are not evidence. We see a lot of petitions, people put them in. I understand why they do it, but I personally would never cite to a petition in a brief because it would run right into the issue that was decided in the case of City of Apopka versus Orange County, which is that an application cannot be denied based solely on layman's opinions unsubstantiated by any competent facts. That's also the case that zoning is not a plebiscite comes from. So headcount and mere community sentiment can't be used to support a decision on appeal. It has to be some kind of fact that describes how this relates to how this proposed project relates to your neighborhood. I want to take a moment to talk about traffic because that comes up in virtually every application. So to opine about whether something is going to cause traffic requires expertise. There are a number of other things that require expertise. And so if you're going to give an opinion about it, you have to be somebody who is trained in that area. The staff report, that's expert opinions. They're trained in this area. Architects, engineers, traffic engineers, they can give their opinions. If you are a member of the public who has a special expertise and you disclose that on the record, this is my training, this is what I've studied, these are the degrees I have, then that might be something that, that we could rely on in supporting the decision. But if you're a neighbor or you're another or other lay witness who does not have expertise, you can't testify, or certainly we can't in a brief rely on testimony that a development will increase traffic over accepted levels, that a development is going to increase flooding, or that a development is going to decrease property values. Those are areas that you need some expertise in order to give that opinion. But, so testimony about traffic is particularly tricky, and as I mentioned, it usually requires an appropriately credentialed expert. But lay testimony can establish, you can describe the facts of your current traffic conditions. And usually what will happen is the application and the staff report will document how much traffic is expected to increase. So you're not, as a layperson, making the opinion that traffic is going to increase. You're relying on the materials that are already in the record. You could provide a fact-based observation. For example, and this is loosely paraphrased from one that we actually had. It already takes me 15 minutes to get out of my house and get to the signal at the end of the block. Adding any more traffic is untenable. I wouldn't say it exactly that way. I'm not quoting exactly the one that we used. But we did have a case where we were successful in defending the board's decision to deny an application. And there was testimony about the impact to that effect. And that's a fact. I can come and observe to the board under oath that I take 15 minutes to get out of my house. And so that's something that the board could consider. I will also say, if there's going to be expert testimony or testimony by an expert, the code requires that documents that are going to be presented into evidence at the hearing by an expert have to be filed with the zoning director at least 10 days before the hearing. And anybody who's going to give an opinion testimony, an expert opinion testimony, has to have filed a written disclosure of generally what their testimony is going to be. Also 10 days prior to the hearing, file that with the zoning director.
Very good.
So,
okay, so let's go to the last slide, I think it is, about somewhere about the public participation process in a virtual world. And then I want to be sure I have a few good questions I want to share, but I want to let you finish the presentation. Thank you, Dennis.
Sure. So virtual meetings present, I think, both a challenge and an opportunity. We have, I think, we've done the best we can to try to replicate what would be possible in an in-person meeting, but in a virtual format. And we'll see how it goes tomorrow. It'll be our first virtual zoning meeting, but but the idea of the procedures that are being put in place is so that we observe due process for the potentially numerous parties who are interested in the zoning application by ensuring that that people who want to present evidence are able to submit the evidence to the county and it'll be shown at the appropriate time. That they're able to participate through numerous media. So you can do it through Zoom, you can do it by calling in, you can watch a webcast, you can watch it on TV. And we have to balance that against the need for internet security. Which is why we don't, ITD has not allowed members of the public to share their screens to show documents. It's why we require the documents to be submitted to county staff for county staff to show at the appropriate time, because the board and the county need to be able to manage what gets shown on a county screen, and also for the chair to have an ability to manage the meetings, which is always the role of the chair under normal circumstances. So we think that by providing numerous avenues for the public to participate and to submit materials to be presented to the board during the hearing, that we have found a way to move forward while complying with the due process requirements for quasi-judicial applications. Zoning is uniquely difficult in this context because of the potential for numerous parties. So that's the last slide.
Very good. Well, Dennis, thank you so much for this cram course workshop. Really appreciative. And we have some really interesting, diverse questions that I'd like to ask. Now, what if you are someone who wants to make improvements in land use? You're just a citizen. So for example, Roz Rahman from Kendall is interested in bicycle infrastructure. And she wants to know how should a resident think about suggesting sidewalks? uh, in a particular area. She names Southwest 120th Street by Tamiami Airport, where it's often very dangerous, a lot of cars moving quickly. So what should a person do from a land use perspective or zoning to kind of facilitate that kind of infrastructure?
Well, I think by the time you get to the zoning stage, you're really talking about applying policies that the board has already put in place. And so I would say engage your local commissioner to express these issues. And specifically, since the question was about sidewalks, that's really a public works type of issue. And so I think at the zoning stage, the way I guess it could come up would be if you have a specific project that's large enough to merit that sort of consideration, that might be the sort of thing that if there's a site plan that you can comment on where the sidewalk should be or how it could connect up if there's a site plan before you. I do want to, sorry, go ahead.
Well, I'm just thinking of some projects where I brought up about bicycle infrastructure at the zoning hearing, where I was able to press a developer to incorporate some bicycle amenities. It wasn't a requirement, but aren't there elements in our CDMP that talk to safety or mobility issues that can be used to advocate?
Well, the CDMP does have policies regarding encouraging non-motorized transportation, but how they come into play in any particular zoning application, that's the trick. I think the way I've seen it come up more is when staff has done, say, an urban center rezoning where they're designing an entire new area and providing basically a new zoning code with streets and bike paths that they want to see for the future development. So I would say that kind of issue for the most part is better as a policy-making function than on a site-specific. Because I do want to point out, when you're talking about imposing a condition on a development, I had mentioned the takings claim at the outset. One of the things that we have to be cognizant of if we're going to advise the board about whether a condition is lawful is we have to ensure that it is not an unlawful exaction. An exaction is when you impose a condition, could be monetary or it could be some other type of condition on an approval. There's a requirement under the case law and also under the Florida statutes for certain of these that any sort of condition has to be roughly proportional to the and have an essential nexus to the impacts of the application. So the example from one of the cases is somebody wanted to build a single family home. They wanted to just renovate their single family home. It was on a beachfront property. And as a condition of a permit, the local government, in that case, it was in California, said, well, we, in exchange for giving you the building permit, we insist that you dedicate to us an easement for public access to the beach, even though the house was not going to be in any way blocking what beach access there was otherwise available. And the court in that case said that there was no nexus between the permit that was being sought and the exaction that was being demanded. So that gives you a sense of what we have to look at when we hear about conditions that somebody wants to impose on an application.
So that leads to a question about covenants. So what are covenants and when do they apply? When are they appropriate?
So one of my favorite topics of endless complexity. So covenants are they're legal instruments that are proffered by the applicant, and they usually arise, not always, they usually arise in the context of a rezoning. So the case law in Florida has been that when you have a rezoning, your only choice is to go from one zoning district to another. Let's say you wanted to go from a residential district to a business district. Under the case law, the board is not supposed to consider all of the the very specific things that somebody might or might not do on the property. But there are some properties that are uniquely situated where you don't have just such a clean decision, because it may be that some business uses are appropriate in that location, but others are not. And so what applicants started doing, and I think Bob Trorig was the first to do these, what applicants would do was to induce the board to approve without going against what the law says, which is we can't condition your rezoning. You're either rezoned or you're not. Applicants would say, okay, I'm going to voluntarily restrict my property as an inducement for you to approve my rezoning. And so even though you can't make me keep out certain more intense uses, I'm going to voluntarily put them in this covenant on my property. And so the covenant, when it gets accepted through the zoning hearing process, through a public hearing, it then has to go back through that process for modifications. And so the covenant becomes part of the regulatory regime that governs that land. And so the covenant is basically it's of equal dignity of the zoning district, and it becomes like the zoning district. Covenants get complicated because they're also legal instruments that bind property owners. And so to change them, you also need not just the board to approve it as you would in a rezoning, but you need all of the property owners who are subject to the covenant, depending on the terms of that specific covenant, they need to approve it as well. So that's a word about covenants.
Okay, great. All right, so we have a question from Sydney Robinson about that there are uses on property that are illegal, and that the mechanism for enforcing aren't that effective. So for example, in the agricultural area, we've had this problem about illegal truck parking, which we've attempted to deal with today as well by changing the land use to allow for some truck parking. And ideally then enforcing truck parking where it's not allowed. But if you could comment on the sorts of things that can be done when land use is not followed.
That's what enforcement action is for. That I don't really have much that I can comment on beyond that.
Okay, and let me go back to more questions here. We had a question. There was a recent application in my district. Killian Park was the application, and after a substantial public participation process with lots of community concerns expressed, the applicant withdrew the application. And I, of course, as commissioner of the district, was very clear that if there was substantial community opposition and not support, then I wasn't going to be supportive of the application. And so indeed the application was withdrawn. And the question is, is there any timeline for submission of another application, theoretically, and what would that be, and what would be the public participation process?
Well, since this application was withdrawn, it would go through the same process that this one went through. I'm intimately familiar with it. I was on that hearing. It was a robust public hearing. And there's no particular time frame for when a new application could come back. The code provides 3 cycles for filing CDMP amendments. There's January, May, and October. But there's also the ability to apply on an expedited basis at any time. So the only thing I can really offer is that if and when a new application is filed, it'll go through the exact same process and would start at the exact same, it would start over and it would go first to community council.
And first it would be whatever the proposal would be evaluated by staff. There'd be staff recommendations.
Correct.
That would be presented at community council and the planning advisory board. Okay, very good. And there was another question, the ag, the bicycle. Okay, so Diane Lockwood of the League of Women Voters, and she chairs the environmental committee, asked, when and why land use was added to zoning designations. Land zoned ag cannot be developed, but added land use designation seems like a loophole for developers.
So this was what I started to answer at the beginning about the history of zoning versus growth management. And so I think it's a good opportunity to recap this because I hear this with some frequency. The zoning is what controls directly what you can pull permits for. And so if you're currently zoned ag, that's what it is. The land use plan map is the future vision for what it's going to be. So it doesn't mean that you have to rezone it to that now. It does mean that if you're going to file an application to rezone the property, it has to go in the direction of what the comprehensive plan, land use plan map says, but you don't have to do it right away. And so I don't think it's fair to call it a loophole. It's the state Growth Management Act, the Community Planning Act says that we have to have a comp plan. Part of that comp plan has to have a land use plan map that shows the designations that the commission thinks are appropriate for a property, a large area, and then that's supposed to govern future zoning decisions. So it's really following the steps that the statute lays out. But the reason that you have the disconnect is because the zoning came first, and then the requirement to have the Constitution came later.
Okay. All right. Well, we don't have other questions in the queue, but are there any closing remarks you'd like to make, Dennis?
Just to thank you for the opportunity to share this with you and with the public. I do enjoy talking about it. It's why I teach, and I hope it's been of some value in helping guide people as they make their comments. Our interest here is really in just having a clean and robust and thoroughly vetted process.
Thank you. Thank you so much. I think it's really clear that you are extremely conscientious and knowledgeable, and you guide all of us very carefully. And even when we say things that are not well informed, you're very kind. I said to you before, but truthfully, I do consider that these are the most difficult of my tasks as a county commissioner, because it does have such an immediate impact on the quality of life of everybody. And you know, the values of your property, your enjoyment of your property, potential nuisances, and diminution of value or possible increase in value. I mean, all of these decisions affect your property, but also your quality of life. And so I know that I take them extremely seriously. And I want to thank here personally Sean McCracken, my chief of policy and planning, who is extremely knowledgeable about these as well and guides me through. So you can give me the credit and him the blame. No, just the other way around. You can give him the credit and me the blame if the decisions don't go well, because he certainly is working extremely hard to make sure to bring knowledge and help me make very difficult judgment decisions on these matters. So I take it very seriously. I really want to respect community input, and that is why we're having this seminar. So I really wanted to try to level the playing field for people who are coming as individuals, not necessarily part of a big business with paid counsel, and give you some tools so you can be as effective as possible in your advocacy. And land use, talk to me. Zoning, talk to your friends and neighbors. So with that, we'll close out, and this will be archived for anyone who wants to look at it. And again, thank you so much, Dennis, for joining us tonight.
Thank you for having me.
All right. Thanks, everybody. Good night.